Welcome to the Supreme Grammar Podcast, where you'll learn to write like a Supreme Court Justice. With me, Jill Barton. Today, our AI hosts break down how to build a persuasive trial court motion, piece by piece, from the caption and introduction to the final conclusion. It's a challenging assignment, but with the right approach, it's absolutely doable. Let's listen in for some tips.
All right, so let's dive into something that I know can be a little bit daunting for law students. Legal writing.
Yeah.
Specifically, we're tackling how to write a solid motion for trial court.
Okay.
I remember when I first started out feeling totally lost.
It's a common feeling. There's just so much to learn and the stakes feel so high.
Absolutely. But here's the good news.
Okay.
It doesn't have to be overwhelming.
Right.
We're going to break down a step-by-step approach from the handbook for the new legal writer.
Okay.
That takes the mystery out of motion writing.
What I find so helpful about this handbook is that it offers a practical framework
Yes.
that you can apply to any motion.
That's right. And it all boils down to a handy acronym,
Okay.
CREAC.
I love a good acronym.
Right. Have you found that to be a useful tool?
I have, actually.
Yeah.
It helps ensure that you're addressing all the key elements of a persuasive argument in a logical order.
Right.
C stands for conclusion.
Okay.
R for rule.
Got it.
E for explanation, A for analysis.
Okay.
And then we circle back to C for conclusion again.
Two conclusions.
Yeah.
I have to admit, that threw me off at first.
I can see why.
Yeah.
But think of it this way. You're bookending your argument.
Okay.
So you start by telling the court exactly what you want,
Yeah.
conclusion.
Got it.
Then you build your case step by step,
Right.
backing up your request with the relevant rule, explaining it clearly,
Okay.
analyzing how it applies to the specific facts of your case,
Yes.
and finally bringing it all home by restating your conclusion.
That makes a lot of sense. It's like giving the judge a roadmap
Exactly.
from the very beginning.
Exactly. So how does the handbook suggest we actually begin crafting the motion?
Well, before we even start writing, the handbook emphasizes the importance of creating a template.
Okay. This seems like a basic step, but it's crucial, isn't it?
It really is.
Yeah.
Think of it like building a house.
Mm-hmm.
You wouldn't start constructing the walls without a solid foundation. The template ensures you're following the specific rules and formatting requirements for the court where you're filing your motion.
And those can vary quite a bit, right?
Absolutely.
From court to
The
court.
court has its own preferences.
Yeah.
That's why the handbook stresses the importance of carefully reviewing the local rules
Right.
before you do anything else.
Yeah.
Ignoring those rules could lead to your motion being rejected outright.
Oh, that would be a nightmare.
It would. So within the template,
Okay.
there are a couple of key parts to pay close attention to.
Right.
First, the caption.
Yes.
This is where you include all the essential information about the case.
Right.
The court's name, the parties involved, the case number.
It's like the header that sets the stage for the whole document.
Exactly. And then at the very end, you have the signature block where you sign your name and provide your contact information.
Seems straightforward,
Right.
but even these basic elements can trip people up.
You're telling me? I remember spending way too long trying to figure out the proper formatting for a signature block.
That's why I appreciate the handbook's emphasis on the template.
Yes.
It sets you up for success from the start.
Once we have that solid foundation,
Yeah.
what's the next step in building our argument?
Well, according to the handbook, it's time to craft a persuasive facts or background section.
This is where we get to tell our client's story, right?
Yes, but it's not just about summarizing what happened.
Right.
The handbook really emphasizes that the facts section is an opportunity to present a compelling narrative that supports your argument.
It's interesting because I think a lot of law students approach the facts section as a purely objective summary of the events.
I see that a lot too.
Yeah.
But in reality, the way you present the facts can significantly impact how the judge perceives the case.
Right.
You're not making things up, but you are strategically choosing which details to emphasize and how to frame the narrative.
The handbook gave an example that really stuck with me. It talked about two parties involved in a business dispute. Simply by emphasizing certain details and the order in which events occurred, the attorney was able to create a more sympathetic portrayal of their client.
It's amazing how subtle shifts in emphasis can completely change the tone and impact of the story.
Absolutely. And the handbook highlights some helpful techniques for achieving that.
Okay.
For example, they mentioned something called the primacy and recency effects.
I'm familiar with those from psychology.
Yes.
It suggests that people tend to remember the first and last things they hear, or read more vividly.
Exactly. So the handbook suggests placing your strongest facts at the beginning and end of the facts section
Oh, okay.
to make a lasting impression.
It's like a good opening and closing argument, right? You want to grab the judge's attention from the start
Right.
and leave them with a powerful image at the end.
It makes so much sense when you put it that way.
Yeah.
But even as we're crafting this persuasive narrative, the handbook reminds us to be mindful of our ethical obligations. We have a duty to be truthful and accurate
Right.
in our representations.
Absolutely.
Right.
Yeah.
So while we want to present the facts in a way that supports our client, we can't omit or distort information that might be unfavorable.
In fact, addressing potentially unfavorable facts head on
Yeah.
can actually bolster your credibility.
Interesting.
It shows you're not trying to hide anything from the court.
I've heard that referred to as taking the sting out of a potentially damaging piece of information.
Exactly. By proactively addressing it and explaining why it doesn't undermine your overall argument,
Right.
you can prevent the other side from using it against you.
That's a great strategy. And sometimes when you're dealing with a lot of facts, the handbook suggests using subheadings within the facts section.
That's a helpful tip. Especially in complex cases, subheadings can make the information more digestible
Right.
and easier to navigate.
You're like signposts guiding the reader through the story.
And remember, even though we're trying to be persuasive, clarity is paramount. The judge should be able to easily follow the chronology of events
Right.
and understand the key facts of the case.
That's a great point.
Yeah.
No matter how well crafted our narrative is, it won't be effective if the judge can't understand it.
So we've laid out the facts persuasively and ethically.
Yes.
What comes next?
Well, not all motions require a deep dive into the specific legal standard.
Right.
But when they do, the handbook says that's our next step.
This is where we move from storytelling to legal analysis, right?
Yes, and it can be a bit trickier.
This is where a solid understanding of the relevant law is essential.
Right.
For motions like a motion to dismiss,
Yes.
you need to clearly articulate the legal standard the court will use to evaluate the case.
For instance, in a motion to dismiss, both sides will be arguing about how the same legal standard applies to the facts.
Exactly. And this is where things can get really interesting.
Okay.
Both sides will be trying to present the same law in a way that benefits their client.
Right.
You're essentially arguing about how the law, when applied to the specific facts of your case, supports the outcome you're seeking.
So it's not just about stating the law, it's about strategically framing it to support your argument.
Precisely. You need to find and cite strong case law that bolsters your interpretation.
This is definitely where a good legal research strategy comes in handy.
Absolutely.
Yeah.
We'll delve deeper into that later.
Okay.
But for now, let's move on to the next step in crafting a compelling motion.
The handbook refers to this step as guiding the court with umbrellas and subheadings.
Yes. The art of structuring your arguments effectively.
Exactly. It's all about making your motion as clear and persuasive as possible.
Think of it this way. You've laid out the foundation with your template
Okay.
and told a compelling story with your facts section.
Yes.
Now you need to present your legal arguments in a way that's easy for the judge to follow and understand.
I like how the handbook uses the term umbrellas.
Yeah.
It's a great analogy.
It is, umbrellas are like mini roadmaps for the court, telling them what arguments are coming next and how they connect to your overall case.
They help organize the information
Yeah.
and guide the reader through your line of reasoning.
They're crucial for maintaining clarity, especially in longer or more complex motions.
Right.
The handbook actually cites the Hawaii v. Trump case as a great example of this.
Oh, yes. That was a really complex case.
It was.
Didn't they use subheadings to break down their arguments into more manageable chunks?
They did, and it made their overall argument much easier to follow.
Okay.
Remember, you want the judge to effortlessly grasp your logic and reasoning.
Yes.
It's about presenting your arguments in a way that makes them impossible to ignore.
It's like making a delicious multi-layered cake.
I see what you did there.
Each layer has to be carefully crafted and placed in the right order to create a cohesive and satisfying whole.
And speaking of crafting things carefully, the handbook says the next step is writing an introduction that hooks the reader.
This is our chance to make a strong first impression. Like an elevator pitch for our entire motion.
Exactly. The introduction is where you grab the judge's attention right from the start.
Even though it's relatively short, the handbook emphasizes that it should be carefully crafted.
It should.
And I love their suggestion about writing it last.
That's actually a really smart strategy. Once you've written the rest of the motion, you have a clearer picture of the key points you want to emphasize in the introduction.
Plus, it's less pressure that way.
Right.
I know we're running short on time for this part of our deep dive,
Okay.
but I'm curious to hear your thoughts on the final step.
All right.
The handbook outlines scrutinize and revise.
Oh, this step is absolutely crucial. I can't stress it enough.
It's so tempting to just hit submit after hours of writing,
Right.
but the handbook really drives home the importance of taking a step back
Yeah.
and looking at your work with a critical eye.
Remember, the other side will be scrutinizing every word,
Okay.
looking for any weakness they can exploit.
Right.
You need to catch those weaknesses first. Revision is not just about finding typos.
Right.
It's about refining your arguments.
Yes.
Making them tighter, stronger, and more persuasive.
That's like polishing a diamond. You have to carefully examine every facet to bring out its brilliance.
Well said. And that brings us to the end of part 1 of our deep dive into motion writing.
Yeah?
We've covered a lot of ground,
Yes.
from creating a template to crafting a persuasive narrative, and
Right.
we're just getting started.
We'll be back soon with part 2, where we'll explore even more tips and tricks for writing a winning motion. Stay tuned.
Welcome back. Last time we left off talking about the crucial step of revision
Yeah.
in motion writing.
It's so true. Revising isn't just about catching typos.
Right.
It's about looking at your motion with a fresh perspective and making sure your arguments are clear, concise, and persuasive. The handbook has this awesome checklist that's really helpful for scrutinizing your work.
I agree. It's a great way to ensure that you haven't missed any important details. You almost have to approach your own work with a bit of skepticism, like you're opposing counsel trying to find holes in your argument.
I like that.
Yeah.
It's like a mental sparring match, getting ready for the real deal in court.
Right.
So far, we've talked about creating a template, laying out the facts persuasively, and using the CREAC method to structure our arguments.
Right.
What else should we keep in mind as we're crafting our motion?
One thing the handbook stresses is the importance of writing for your audience,
Okay.
which in this case is a judge.
Makes sense.
Yeah.
We're not writing a law review article. We're trying to persuade someone to rule in our favor.
Exactly. Judges are busy people.
Yes.
You don't have time to wade through pages of dense legalese.
Right.
Clarity is key.
Yes.
The handbook recommends avoiding unnecessary jargon and keeping your sentences short and to the point.
It's like the old saying, if you can't explain it simply, you don't understand it well enough.
Right. And of course, accurate citations are a must.
I learned that the hard way my first year. Nothing undermines your credibility faster than sloppy citations.
Yeah.
It's like showing up to a potluck with a delicious dish, but forgetting to bring the recipe.
Oh.
People start to wonder if you even made it yourself.
That's a good analogy. The handbook also delves into the delicate balance between being persuasive
Okay.
and being ethical.
It's something that I think a lot of law students struggle with.
Yeah.
We want to advocate for our clients effectively,
Uh-huh.
but we also have a duty to be honest and forthright in our presentations.
It's a crucial distinction.
Yes.
Zealously representing your client and upholding ethical standards are not mutually exclusive.
Right.
They go hand in hand.
That's a really encouraging perspective.
Yeah.
It's not about winning at all costs.
Right.
It's about using your skills to advocate for your client within the bounds of the law.
Exactly. And it's important to remember that legal writing is a skill that develops over time.
Yes.
Nobody expects you to be a master motion writer right out of law school.
I needed to hear that when I was starting out.
Yeah.
It's easy to get intimidated by the polished writing you see in published cases.
It's like learning to play a musical instrument.
Yeah.
It takes practice and patience.
Yes.
The more you write, the better you'll become.
Right.
And frameworks like CREAC are a great tool to help you develop those skills.
They provide that structure and guidance until you're confident enough to fly solo.
Right.
Now, I want to circle back to something we discussed earlier.
Okay.
The idea of presenting facts persuasively.
Uh-huh.
I think this is a real stumbling block for a lot of new legal writers.
It's understandable.
Yeah.
In law school, we're often trained to analyze both sides of an issue objectively.
Right.
But in persuasive writing, the goal is to advocate effectively for your client's position.
It requires a shift in mindset from neutral observer to strategic storyteller.
That's a great way to put it.
Yeah.
And the handbook offers some valuable tips on how to do that ethically.
Okay.
For example, they talk about the strategic use of language. Instead of simply saying the plaintiff fell,
Okay.
you might say the plaintiff was severely injured in a dangerous fall.
Right.
Both statements are factually accurate,
Yes.
but the second one paints a more vivid picture and evokes more empathy for the plaintiff.
It's like adding a dash of storytelling spice to your legal writing.
Right. The handbook also brought up an interesting point about using emotional facts.
It does seem a bit counterintuitive because we tend to think of the law as being all about logic and reason.
Yeah, but the handbook argues that connecting with the judge on an emotional level can be quite effective.
You're not appealing to emotions instead of logic.
Right.
You're adding another layer to your argument.
Precisely. It's about making the judge care about your client's story.
Right.
For example, in a personal injury case, you might include details about the impact of the injury on the plaintiff's life,
Right.
their inability to work their emotional distress, the financial burden.
Okay.
These details humanize the case and make it more than just a legal dispute.
It goes back to that idea that people may not remember exactly what you said,
Right.
but they'll remember how you made them feel.
That's a powerful concept to keep in mind as you're crafting your motion.
Yeah.
By ethically incorporating emotional facts into your narrative, you can create a more compelling argument that resonates with the judge on a deeper level.
This has been fascinating.
We've covered a lot of ground, from the initial steps of creating a template and weaving a persuasive narrative with the facts to structuring our arguments effectively using the CREAC framework.
We even touched upon the importance of writing with clarity.
Right.
Using emotional facts strategically and always upholding ethical standards. But there's one final gem from the handbook for the new legal writer that I think is the perfect note to end on.
I think I know what you're referring to.
Okay.
The importance of practice.
That's the one. Nobody becomes a master motion writer overnight. It takes dedication and a willingness to learn from your mistakes.
It's like any skill worth mastering. You're going to encounter bumps along the way. The key is to keep practicing and refining your craft.
The handbook makes a comparison to learning to ride a bike. You might wobble, you might even fall a few times, but eventually you find your balance and you're cruising down the road with confidence.
That's a great analogy, and it applies perfectly to legal writing. Embrace the challenge. Seek feedback from experienced attorneys.
Right.
And never stop honing your skills.
It's encouraging to remember that every great legal writer started somewhere. Even the most seasoned judges and attorneys were once law students grappling with their first motions.
It's easy to get intimidated by the polished legal writing you see in published cases or scholarly articles. But remember, that level of skill and finesse comes with time and practice.
So don't be discouraged if your first attempts aren't perfect. The important thing is to keep writing, keep learning, and keep striving to improve.
I couldn't agree more. And never underestimate the power of clear, concise, and persuasive legal writing.
Yes.
It can truly make a difference in people's lives.
That's what makes this all so worthwhile, isn't it? Whether you're advocating for your client's rights in a negotiation or fighting for justice in a courtroom, the ability to communicate effectively through legal writing is an invaluable skill.
It's a skill that will serve you well throughout your legal career and beyond.
Well, folks, that brings us to the end of our deep dive into motion writing.
It's been a pleasure.
We hope you found it insightful, encouraging, and maybe even a little bit inspiring.
Remember, the CREAC framework is a fantastic tool to have in your legal writing toolbox.
Yes.
So go forth, write those motions, and make a difference.
And until next time, keep on learning, keep on growing, and keep on diving deep.
So when you treat emotion as a series of smaller steps, the intro, the facts, and each part of the CREAC analysis, the task becomes far less daunting. You'll find more tips in chapters 31 and 32 of the Handbook for the New Legal Writer. And remember, you can be a great legal writer.